the record in the matter of the people of the city of Lansing versus Rambo L, file numbers 22L2761882, 881, and 883. Council appearance, please.
Matt Staples on behalf of the city of Lansing.
Okay, and then Rambo L is present. Do you have an attorney, sir?
I'm here by special appearance.
Okay. Mr. Staples, my understanding is that you're moving to dismiss these.
Just the failure to display ops, Your Honor. I did check the Secretary of State. His license is valid, and he did show me that license, and that he does have it in his possession, so that the misdemeanor charge would be dismissed.
Okay, and there's no offer on the expired plate and the failed signal?
Not at this time, Your Honor. I believe Mr. L is planning on contesting those charges.
Is that correct, Mr. L?
Yes.
Okay, we'll set them for a hearing. February 14th at 9:30. Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Okay, you're all set, Mr. L. We'll see you on February 14th. Okay, is this L Rambo or Rambo L? You're muted. You have an attorney, sir?
No, I'm here by special appearance.
Okay, I'll put you in the private meeting room with the city attorney.
Your Honor, we've actually already met with Mr. Rambo L before. He was requesting a formal hearing on these two files.
Okay, sounds good. Formal hearings will be set for in-person appearance.
Actually, I filed a motion January 6th. This is when it went unanswered. I would like the court to dismiss this matter.
Welcome back to the channel, everyone. Buckle up, because today we're diving into one of the most entertaining courtroom showdowns you'll ever see, featuring everyone's favorite flavor, chaos, a sovereign citizen who believes he's above traffic laws and U.S. jurisdiction itself. This case, the people of the city of Lansing versus Rambo L, perfectly captures the bizarre logic, courtroom confusion, and ironclad patience of a judge dealing with what I can only describe as legal fantasy roleplay. Throughout today's video, we'll witness 3 separate hearings, each more unhinged than the last, as Mr. Rambo attempts to convince a Michigan judge that the laws of the land simply don't apply to him.
Motion for challenge of jurisdiction that I submitted to the clerk, and I've served everybody, all parties. How long does he have? Because that happened January 6th.
I see it's a motion to show authority.
And also a demand for dismissal, lack of jurisdiction, failure to introduce evidence of an injury in fact, challenges jurisdiction of the court to prosecute. That was filed January 6th.
We only have one motion attached to the file. I don't see the other motions that you're referencing, sir.
It's timestamped by the court. I have it right here.
I see a motion to show authority, which the court has denied. And then there was a memo that was attached. There was not any other motion. I don't read via Zoom.
It's filed with the clerk. Everybody was served.
Mr. Staples, did you get a copy of the motion he's referencing?
I see a copy of the motion to show authority in our file. I don't recognize it as any sort of valid motion or pleadings, but I see a copy of it in our file.
Agreed. That's the same the court has. It's a motion to show authority. The other motions that he's referencing was not properly filed with this court or served as the court. Neither the court nor Mr. Staples' office is in receipt of it. The motion to show authority was denied. Is not in proportion with the Michigan court rules. It does cite, however, Luke 11:46, the King James version, Luke 11:52, as well as some other articles.
And there it is, the moment of pure irony. The defendant proudly claims a right to travel, yet he's holding a valid driver's license, the very document that proves he recognizes a government authority to regulate driving. You can almost hear the contradiction echo through Courtroom. Sovereign citizens often argue that driving is a constitutional right, not a privilege. But every U.S. court, including the Supreme Court, has repeatedly ruled otherwise. Driving requires a license because it's a regulated activity, not just movement.
But nonetheless, as indicated by Mr. Staples from the Office of City Attorney, this is not a lawful or appropriately filed motion, and for that reason, it was denied before this court. But we will
Well,
set your matter.
I like to challenge jurisdiction right now. I have the right to
You can file an
travel.
appropriate motion with the court under the Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James Version of the Bible. Okay?
That was a different motion you're referring to. That was the motion to show authority.
We don't have the other motion, sir. So you can file that motion. It's just we don't have it. I don't know why we only have one motion. That we don't have the other one you're referencing. So you'd have to file that and serve it on the city attorney. We'll give you time to do that. I'm going to set both of these matters for hearing, though.
I can't chill. You telling me I don't have the right to challenge jurisdiction right now? I want to challenge jurisdiction right now.
You can file a motion for challenging the jurisdiction, sir.
I can't do a verbal motion?
No, you cannot.
So you telling me I don't have the right to do a verbal motion?
You don't have a right to do that. You're going to file it in writing and you're going to serve it properly on the parties that you're filing it against. Okay, sir? March 14th at 10:30 in person at the court will be the date for the formal hearing, and then we'll hear any arguments on motions if necessary. You have any questions today, Mr. L? There's a date and time set for a formal hearing. I have, I believe, one witness on Zoom. Counsel, you can proceed.
Officer Vanderwerf, would you state your name for the records,
Oh,
please?
you want to call him? Let me.
Oh, I'm sorry.
Sir, man, no worries. Vanderwerf, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Judge.
Here we go. The classic motion to dismiss without reason play. He's demanding the court drop his charges simply because, well, he feels like it. No legal foundation, no statutory citation, no argument, just vibes and paperwork. This is where many sovereign citizens falter. They read just enough pseudo-legal nonsense online to sound confident, but not enough to understand court procedure. Motions aren't magic spells. They require specific grounds and supporting evidence.
When I observed a pickup truck in front of me that was changing lanes, failing to use its signal. So at that time, I activated my overhead lights on the vehicle to initiate a traffic stop. And then I made contact with the driver, who was later identified as a Rambo L. In our contact, he ended up handing me a piece of paper. At brief glance, when I looked at the piece of paper, it appeared to have what I believe was certain MCL codes that the subject may have typed onto the piece of paper. When I had asked him for a driver's license or identification, he was not really very cooperative. I also don't believe I was provided any insurance. At that time, I decided to issue him a citation for failing to signal, changing lanes, and failing to display a valid license, and then also the license plate through the system was expired.
Mr. L, did you want to question the witness?
Yes. The document that you were referring to, it was a travel document. I was showing you, I was traveling versus driving, and I tried to explain that to you. And then you held me on the side of the road for approximately an hour. I requested a supervisor because they might better understand what I was doing, and you never provided that for me. Is that correct?
That's actually incorrect, because the reason that you were held on the stop for as long as you were is because I was waiting for a supervisor. So when I realized the supervisor was not there, I contacted him by phone, at which time he said he was delayed. And when I came back up to the traffic stop, I did ask if you wanted to wait further for a sergeant, and I don't believe that you did. And then you drove off when you were free to go.
Yes. is it correct that I was held on the road for approximately an hour waiting for this whole encounter to end?
I do not remember if it was an hour specifically, but I do remember that the time length was probably, I would say probably close to that at the very least.
Well, it was an hour and it caused me to be late for my son's
Did you
banquet.
catch that? The defendant actually cited Luke 11 verse 46 and Luke 11 verse 52, as if the King James Bible was part of the Michigan court rules. This is the peak of sovereign citizen theater, mixing scripture with statutes and calling it a motion. Judges deal with this all the time. Filings that quote religious texts, maritime law, or even the UCC, Uniform Commercial Code, as if they override state law. But here's the truth. No matter how passionately you quote the Bible, it won't overrule a traffic citation.
The reason, and I never got to speak to a supervisor. That's all the questions I had.
Okay, any redirect?
No redirect, Your Honor.
Okay, any additional witnesses today?
None from the city.
Okay, Mr. Earl, are you calling any witnesses today, or did you want to give your own testimony?
I would like to, I have something, I have a defense, my motion.
Okay, well, you filed a motion?
Yeah, I filed a motion, served across the
When did
city
you file a
attorney.
motion?
It was filed, it was mailed February 18th.
You filed a motion and mailed it February 18th. Did you serve a copy?
To the clerk of the courts and also to the city attorney's office.
Did you receive any motion, sir?
Your Honor, we did receive a motion. It did not have any hearing date stated on it. We had no timetable for a response. I would be happy to respond to the motion on the record orally or provide the court with briefing if they would like.
The court didn't get a copy of the motion in February.
I sent it to the clerk.
Yeah,
And,
typically when that happens, it's just attached to the file. I don't have a copy of any motion.
well, I did my due diligence. I sent a copy to him. He has his.
Well, I don't know that you did your due diligence, because when you file a motion, you got to get a hearing date for that motion. And so
Who's supposed to give me a hearing?
you got to get the hearing date from the clerk's office.
From the clerk's office?
Yeah.
So why did they give me one?
Did you contact them for a hearing date?
I contacted them, yeah.
And asked for
And I
hearing
asked
dates
them,
for your
and I
motion?
asked when was my hearing. They confirmed that it was today.
For your motion.
And I asked, did I have a hearing date? And they
But-
said, now comes the beneficiary for Rambo L, defendant in error, hereby special appearance, not submitting to the court's jurisdiction, hereby moves the court to strike and dismiss the complaint filed by the officer, Zenderbarth. Am I pronouncing that right? Sorry if I'm not. For lack of ratification and commencement, no corpus delicti, no plaintiff lacks jurisdiction, personal for firm jurisdiction. Christina Simmons being appointed as trustee, the prosecutors being appointed as co-trustee, I, Rambo L, an executor and beneficiary of a set of account. Also, I filed a declaration of non-citizenship nationality because
They love this phrase because they think saying it instantly halts the case, like a courtroom cheat code. Unfortunately, it doesn't work like that. Jurisdiction challenges must be filed in writing with proper service to the opposing party. When the judge tells them that verbal motions don't count, you can almost sense the disappointment. But what's more impressive here is the judge's patience. She gives him multiple opportunities to follow procedure instead of just shutting him down.
where my point of authorities are the United States District of Columbia Corporation in Volume 20, Corpus Juris Section 1785, we find United States government as a foreign corporations with respect to the states. Since the corporation is fictitious, is a fictitious person, it can't see, speak, smell, or touch itself. It's a fictional. Is a fiction in the real world. It needs a conducting, transmitting utility, allegiance, some sort of connection to a fictional person. Constitutional Amendment number 1, Congress shall make no law respecting an establishment of a religion, prohibiting free exercise thereof, abridging freedom of speech, or right of press, or right of people peaceful assemble, petition the government for redress of grievance. Number 5, constitutional amendment. The right of people should be secure in their person, houses, papers, in effect against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by an oath or affirmation, particularly describing the place search of persons, things to be seized. And then number 7, constitutional amendment, suits at common law where value of controversy exceeding $20, the right of a jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. I asked for a jury. Rambo L is a man, people, but not a person. I was not operating in commerce, nor was I a driver on the road for travel. A driver is an employee transporting goods or passengers. Rambo was just merely traveling in my private property. Here are some examples of my Supreme Court constitutional defenses. Number 1, case number 1, the right to travel is part of a liberty where a citizen cannot be deprived of due process under the Fifth Amendment. Kent versus Duels, 357 U.S. 116 120.
The officer's testimony is straightforward, professional, and most importantly, consistent. Yet our defendant tries to spin it into a constitutional crisis about traveling versus driving. What makes this moment so revealing is the sheer lack of accountability. Instead of acknowledging that he broke traffic laws, he blames the officer for detaining him too long, even though he's the one who requested the supervisor that caused the delay. This pattern is common. Sovereign citizens often project blame outward to maintain the illusion of victim.
618, that right is so basic, it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously perverted my right into a privilege and issue a license and a fee for it. Murdoch versus Pennsylvania, 319 U.S. 105. Supreme Court trumps everything. Says that no state can convert a secured liberty into a privilege and issue a license and fee for it. Case number 4, Shuttle versus Birmingham, Alabama. It shows that I can ignore a license and engage in the right with immunity. Case number 5, Marbury versus Madison, 5 U.S. 137 shows that any law in violation of the Constitution is null and void. Case number 6, Shuttleworth versus Birmingham, 373 U.S. 262 says I may ignore the license and the fee and engage with the right with immunity. That means you can't punish me. And United States versus Bishop defines willfulness as an evil motive or intent to avoid a known duty task under the law with a morality certain. I submit I couldn't have been doing an evil task. I totally followed the Constitution in the Supreme Court. Bryers versus United States says it shows how the judge is supposed to interpret the Constitution, and it's supposed to be interpreted in the favor of me. A.M. Jurisprudence, Volume 16, Section 97 of the Constitutional Law section says it should be received as a liberal interpretation in favor of the citizen, especially true with respect to those who were designated to safeguard the liberty and security of a citizen in regards to both persons and property. See note 31, Bryers versus United States. No state may convert a liberty into a privilege. Murdoch versus Pennsylvania. An appearance ticket is not an accusatory instrument. It doesn't confer jurisdiction over the defendant. People versus Gabay, 670 New York 2D 92517. I was not engaged in a commercial trade at the time of the alleged infraction, and I do not proceed to say a license is upon a constitutional detention. Motor vehicle means every description of a carrier drawn by mechanical power used in commercial.
This right here is where the fantasy collides with reality. The judge patiently explains that filing a motion isn't as simple as dropping paperwork at the clerk's desk. You need to schedule a hearing, notify all parties, and follow procedural rules. Representing yourself, called Pro SE, sounds empowering, but without legal training, it's a minefield. That's why judges and lawyers constantly warn against it. And yet, our defendant believes the system failed him, when in truth, he just didn't follow basic filing protocol.
Any additional argument on your motion?
I would like the court, I would ask the court to dismiss this for failure to state a claim where relief can be granted.
The court has heard the argument. I'm first address your motion, Mr. L, and I'm going to deny your motion as clearly indicated in the response by the city. Your claims would be most appropriately brought before the Court of Claims, and so you can't challenge a constitutional issue in this court, okay? As it relates to the authority and the process to bring this matter before the district court as it relates to your civil infractions, you have an expired plate and a failure to signal. Again, a jurisdiction or venue before this court is appropriate. This is a situation or incident that occurred in the area of South MLK, Martin Luther King Boulevard. That's in the city of Lansing, Ingham County, state of Michigan. And so you're subject to the laws and the ordinances of the city of Lansing, but also the laws under the Michigan compile laws. Here in this district court, we are subject to the Michigan court rules. And so, although I gave leniency with your motion, it was not properly filed and or served. But it also does not comport with the Michigan compile laws or Michigan court rules. And so for those reasons, it is denied. Now, as to the civil infraction, failed to signal an expired plate from December 3rd, 2022, we do not provide any valid dispute or defense to these civil infractions. You could have appeared and showed information that demonstrated you did have a valid plate at the time, or that you even have one now, which could reduce the citation, but that's not taking place. And so I'm going to sustain both violations of civil infractions. There's a fine of $125 on each. Okay, sir?
My next defense, am this done or can I say something else?
You can say something else. I asked you if you had any further defense, but you said.
My next defense would be, Michigan allows 72 hours to register any vehicle when it's first purchased. He never asked for anything. I never got a chance to explain myself on the side of the road.
Okay, do you have proof that you had just purchased it within 72 hours? If the defense is not meaningful, if you can't provide any evidence to support that defense. That being said, your fine is $125 on each file. When do you intend to make payment?
Do I have a chance to appeal this?
You can.
I would like to appeal.
Okay, you want to file an appeal? It's the civil infraction?
I want to file an appeal today.
Okay, you can file a motion for reconsideration. But you need to follow Michigan court rules, okay? We don't submit to the sovereign rules, okay? You take that to the sovereign court.
And there we have it. Another textbook case of sovereign citizen ideology meeting immovable legal reality. From motion citing Bible verses to arguments about traveling instead of driving, this hearing had it all. Confusion, comedy, and ultimately, closure. The judge maintained control, the prosecutor stayed professional, and the law stood firm. As it always does, so what's the takeaway? Knowledge of the law isn't about memorizing random codes. It's about understanding procedure and jurisdiction, two things no sovereign citizen seems to grasp.